Good afternoon, everyone. Thank you so much for joining us for episode 3 of Planning Shorts. We're delighted that you could join. Let me remind you that we've got the chat function and the Q&A if you'd like to ask any questions, make any comments, and we will do our best to engage with you there. My name is Victoria Hutton. I am a barrister at 39 Essex Chambers, and I am piloting this webinar this evening. The eagle-eyed amongst you will realise that we don't have one of our regular panellists, Dr. Ashley Bowes. He is moving house today, and we figure that that is probably a good enough excuse, so we will excuse him. But we are delighted to say that we have got Neil Tilley with us today. Neil is a director at Pegasus Planning, and he has direct experience of one of the matters that we're going to discuss. So Neil, thank you for joining us. You will see that I have uploaded already to the chat the text of paragraph 11 of the NPPF, the tilted balance, and footnotes 6 and 7. So you can see that there if you want to have reference to it while we're speaking about it. I'm sure you all know it off by heart. And I've also uploaded some of the decisions that we are likely to touch on today. So without further ado, let me ask the panel to briefly introduce themselves, and also to, in view of Ashley's house move, to tell us if they could move anywhere in the world right now, where it would be. Thea, why don't you kick us off?
Hello and good afternoon. I'm Thea Osmund-Smith. I'm a barrister at number 5 Chambers. I'm not quite with it this afternoon because I've been sat in front of my screen all day doing virtual High Court, hence the glass of wine. But in respect of your question, Tora, if I could move anywhere in the world right now, it would be Kefalonia, because it's just a beautiful island and I'd much rather be there than here.
Good choice. Killian, how about you?
Hi, my name's Killian Garvey. I'm a barrister at King's Chambers, and I'm going to say anywhere with a garden. I was about 2 weeks away from completing on a property when lockdown happened, so that fell through. And since then, the walls of my flat have been closing in each day. So anywhere with a garden would be fantastic.
Oh my gosh, well, I'm sure that Ashley can invite you round soon to his flat. Matthew, how about you?
Hi everybody, I'm Matthew Fraser. I'm a barrister at Landmark Chambers, and some friends of mine recently, well not that recently, but late 2019 got back from a holiday in Chernobyl and actually said it's rather nice because they've made it a bit more touristic. And I think the radiation is still quite high, but I'd be quite interested in moving there and checking it out.
Interesting.
Not getting a lot of support for that
I've got
idea.
nothing to say. I've got nothing to say. And Neil, how about you?
Hi, Neil Tiley, Director at Pegasus Group. Given the current lockdown, Isles of Scilly's got no cases of COVID, and you don't have to get on a plane to get there, so that would do me fine at the moment.
That sounds perfect. Certainly better than Chernobyl. Anyway, well, let's get on with it. Today's topic is the tilted balance, and the question we're going to be addressing is it really helping us build, as Boris wants us to in the speech that he's just given this afternoon, or is it losing its effectiveness? So as I said, you've got the text in front of you in the chat function, so do have a look at that. And we're going to start by getting our bearings and looking at what the court has said about the various portions of it. So let's start. Thea, I wonder if you can kick us off. The phrase policies which are most important for determining the application are out of date. Thea, what's meant by that?
Okay, well, I'm going to talk to you about a case called Wavendon from last year and baskets of policies. And I'm sure lots of our viewers will know about this. If you don't, write in the comments, but I don't think there'll be anyone actually. I'm afraid to say this was my least favourite case of 2019. Now, I'd like to think that Mr. Justice Dove would watch Planning Shorts, and in fact, he almost certainly does. So I should say he's a brilliant judge and an excellent human being, of course, one of my favourites. But this judgment changed the way in which a number of appeals were being run and what was generally considered to be the right approach to paragraph 11D almost overnight, including an appeal I was involved in. And because of it, we lost the benefit of the tilted balance and the appeal. So the decision that led to the case concerned proposals for around 200 homes. And in the appeal decision, the Secretary of State concluded that policies of the local plan and the neighbourhood plan were out of date. So the claimant said that having reached that conclusion in respect of policies which were most important, the tilted balance should have been engaged. And so in essence, if one most important policy is out of date, most often boundary policies, then the tilted balance is engaged. And I think that's the way that a lot of people applied it prior to the Wavendon judgment. So the court said no, let's talk about baskets. And you might have heard of the Wavendon basket. And essentially it's a three-stage approach to paragraph 11D. The first is to establish what are the most important policies. And there could be lots. It's policies which the proposals comply with, and also those with which they conflict. So it's not just limited, as some people might think, to those policies which are at the centre of an application or appeal because they're contentious. Secondly, you consider whether those policies are individually up to or out of date. And finally, you arrive at a judgment about whether those policies as a whole, the basket of policies, is up to date or out of date. So the difficulty comes when you've got a mixed basket with some up to date and some out of date policies. Inevitably, you're then engaged in considering what is the most important of the most important policies. So what's the policy that has the determinative effect over the basket as a whole, which of course is a matter of planning judgment and blah, blah, blah. We all know the rest.
Thanks, Thea. Well, plenty there for lawyers and planners to think about. But in your opinion, that judgment, did it widen the application of the tilted balance? Did it restrict it, or was it broadly neutral?
No, I would say it certainly restricted it and made it harder to get into the tilted balance. In the case that I was involved in, before the judgment, the council had ruled that we were in paragraph 11D2 territory because the local plan boundaries were old and out of date. But after the judgment, they relied on the basket, which included the most up-to-date core strategy policies that the inspector considered were the most important of the most important, and so determinative. And so we didn't end up getting the benefit of the tilted balance, which had been a matter of common ground, but of course it was then open to the council to make a different argument. And I think you're right, Tori, it just creates a lot more work for the planners and the lawyers.
Well, we've got no problem with that here. While we're on the subject of out of date, Matthew, you're in court tomorrow, I think, is that right, on the case of Peel Investments? What did the High Court say about that, and what's the Court of Appeal considering tomorrow?
Yeah, absolutely. So Peel, there are lots of different points in Peel. It's a very long judgment. There were, I think, originally 12 grounds of challenge. But the main point, the point that I think the case will end up being remembered for, is to do with the question of if a plan reaches the end of its period, so its specified plan period, does it at that point automatically become out of date for the purposes of MPPF paragraph 11? And Mr. Justice Dove said no, and that what you need to do is do what Bloor-Holmes says, which is to look at whether the policies in question have been overtaken by events on the ground, whether national policies changed, and look at consistency, and that there's no automatic cut-off. As soon as you get to the end of the plan period, the plan's out of date. So the Court of Appeal tomorrow will be looking at whether that's right. And I think it will be a very interesting judgment, regardless of what they say.
Yeah, absolutely. So watch this space, really, for that coming out. And again, while we're in this topic of out of date, one of the ways you can be out of date is, of course, if you don't have enough of a supply of housing land, and that's footnote 7. Now, we're not going to go into how you calculate your requirement. I'm sure people will be glad to hear that. But there has been a lot of noise around the term deliverable at the moment, so in the supply side. Killian, why has there been this recent excitement? What's all that to do with?
Yes, well, that's to do with a case that Neil and I were involved in, where the Secretary of State has consented to judgment about what the meaning of the expression deliverable in the framework means. So if I share my screen, this is the glossary to the MPPF, where the word deliverable is defined. And there are effectively two competing interpretations as to what this means. And the significance is, what can you include in your supply? That's the reason why the question's significant. There's the closed list, which means the only type of sites you can include are those sites specified under A and B, i.e. sites which are not major development that have planning permission, or site which have outline permission for major development, brownfield register, etc., etc. But if you do not fall within those two categories, you therefore cannot qualify as even being a site that could be considered deliverable, therefore you can't be in the supply. That's the closed list. Or you can have the open list, which is that effectively you can include anything subject to there being sufficient evidence. So a classic example is where you have a site where there is a resolution to grant planning permission, but you don't actually have planning permission. On the closed list definition, that can't be included. On the open list, it can. And Neil and I were involved in an appeal where we argued that it was a closed list. We won the appeal and we got a resubmission on the back of that, but then the Secretary of State consented to judgment and said that it's not a closed list.
Right, okay, interesting. So Neil, as Killian said, you were the planner or one of the planners at the inquiry which led to, or the hearing which led to that consent order. From your point of view, was the Secretary of State's position in the consent order, was that expected or did it come out of the blue?
Yeah, to be honest, it was a total bolt out of the blue. I mean, as identified by Killian, there are two different interpretations of the definition have been mooted by various parties. Now, if it's considered as a closed list, the definition provides a very clear framework for assessing and determining the deliverability of a site. If it's if it's used as an open list, it's entirely unclear how it operates, as in what the test is for those other categories of sites. And depending upon how those are assessed, it either gives rise to perverse results in that another site, say a Schlar site, is considered to be more deliverable than a site with outline planning permission, for example, or it requires a decision taker to introduce their own words into the definition. Now, I know we'd all like to introduce our own words into the definition of into policy within the NPPF, but I don't believe that that's really a credible approach, and therefore I maintain that it is a closed list. And indeed, that's set out in the PPG. It's the consistent finding of virtually every Section 78 appeal inspector. It's the consistent interpretation of a large number of LPAs. I've seen a number of witnesses arguing the opposite at appeals, and many have had to concede because it's just not a supportable position that it's an open list. But nevertheless, the Secretary of State has now identified that it is an open list, but unhelpfully hasn't provided any clarity on how it operates. And whichever way it operates is necessarily contrary to the guidance. So we kind of find ourselves in a bit of an uncertain territory at the minute. But the one thing I would take from it is that even if the Secretary of State is right that it's not a closed list per se, the Secretary of State has concluded in an appeal decision at Winsford, I believe the reference is in the chat, that resolutions to grant planning permission cannot be included in the deliverable supply. There's also a long line of appeal decisions which say emerging allocations, at least those that aren't compliant with the existing development plan, cannot be included in the deliverable supply. So even if it's not a closed list per se, I think it's inevitable that it will be treated as operating as a closed list. So whilst there's a lot of noise around this consent order, I'm not sure that it actually moves the goalposts very much at all.
Interesting, thank you. Now at this point, if anyone's been aware of the wine bottle being waved around by Thea, I'm just going to give let everyone know that she's been in court all day, so no judgment here.
I mean, anyone who knows me, Tora, will know that I don't really drink very much at all.
Yeah, I'm sure it's just grape juice. It's just grape juice. Killian, now that we've got this in a consent order from the Secretary of State, is that the matter put to bed, or what are the next steps of this?
No, I don't think it does put it to bed. A consent order is not a binding legal precedent. It's obviously persuasive, but it does not follow from a substantive hearing from a court. Thus, it's not law in the same way an appeal decision is not a legal precedent. So it's still open to parties at appeal to argue the point. Moreover, it's still open to the Secretary of State to disagree with this decision and consent to judgment in another case. while people can still argue about this, and I know many will, I suspect, however, most inspectors will find this consent order to be strongly persuasive, and many will follow it. Indeed, this is the Secretary of State's view after taking legal advice for the purposes of litigation. So I think, to test your analogy of is the issue put to bed, I think the issue is perhaps brushing its teeth, wearing pajamas and getting ready for bed, but it still could be awakened.
Fantastic. Okay, well, again, another thing to look at, and I'm sure it's going to be an argument coming to an inquiry near you in the foreseeable future. Well, actually, on that, we haven't done a poll yet, so let's do a poll. Let's get a bit of audience engagement. Can I ask the audience, in your view, is the NPPF glossary definition a closed list or an open list? So if you'd like to vote on that, that would be fantastic.
Voted already. Fascinated to see the outcome of this.
Great, well, there's lots of votes coming in. I can tell you it is not close. Well, no, there's a few for open. So look, I'm gonna end that now. Thank you for everyone who's taken part in that. So there we are, 75% versus 25%, 75% for closed. So again, that's an issue that I'm sure we're all going to be watching keenly. So let's go back to paragraph 11 and move through its text, and particularly into subparagraph D1, which is the phrase, the application in this framework, the application of policies in this framework that protect areas or assets of particular importance provides a clear reason for refusing the development proposed. Matthew, what have the courts said about that?
Thanks, Tora. And if I could just pull people's attention away from Thea's alcohol consumption just for a moment, I'd be delighted. This is an issue which came up in a case called Monkhill. I was acting for the claimant, led by Charlie Banner QC, and it is all about that part of the framework which is trying to disapply or take you away from the tilted balance if there's a policy in the framework which provides a clear reason for refusing the development. And it was all about, well, what policies in the NPPF are doing that? What policies are providing a clear reason for refusal? Because footnote 6 lists the subject matter of the policies, but it doesn't tell you actually which paragraphs or parts of paragraphs the NPPF means by that. So it's up to the interpretation of the court as to what that is. And what the claimant argued in Monkhill is that in order to be capable of providing a clear reason for refusing the development, a policy in the NPPF has to provide some kind of self-contained test or balance in order to displace what would otherwise be the tilted balance. So, for example, it would be a policy, and there are lots of these in the NPPF, that say permission should be refused unless so-and-so. Or a policy that says development shall only be permitted in exceptional circumstances. Think of the Greenbelt, for example. And so, I mean, the claimant ended up providing a whole schedule of policies that would apply according to this interpretation. And conversely, if a policy like, for example, the beginning of paragraph 172 on AONBs, if a policy simply provides that great weight should be given to a single factor, for example, conserving the AONB, and not explaining how other factors should be balanced and considered within the overall exercise, then that in itself can't be capable of providing a clear reason for refusal, because it necessarily presupposes there's still a balance to be carried out. Mr. Justice Holgate disagreed with that argument in the High Court, saying that he described it as an implicit balance in paragraph 172. So giving great weight to something is triggering an implicit balance, which takes you outside of the tilted balance. So I think at the very least, although I probably would say this, it's a sign of slightly loose language in the NPPF. And interestingly, the claimant has been granted permission to appeal by the Court of Appeal, who've described the point as fully arguable and having a real prospect of success. And that's something to look out for towards the end of this year. It's currently listed for early November 2020.
Great, thank you. And what are the application, I mean, what's the practical application of that? Has that, again, restricted the application of paragraph 11, the tilted balance, or widened it, or is it neutral?
I think it's restricted getting to the tilted balance because it's made it easier, in my view, for people to identify policies in the framework which provide a clear reason of refusal and thereby excluding the tilted balance.
Interesting, thank you. So let's move to the final part of paragraph 11, D Roman 2, the tilted balance. Any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed as a whole. Thea, there's a case very close to your heart dealing with this, of Gladman developments. You were in that case. What was your client's case, and did Mr. Justice Holgate agree?
Okay, well, the second part of the question is really easy to answer. No, Mr. Justice Holgate did not agree. If he's viewing he's the best judge, the best person, just in case. But moving on to what our arguments were, as we've discussed on the show before, there's been an obvious change in the successive appeals concerning major housing development. Now, Gladman keep an eye on all appeal decisions and noticed a troubling pattern that an appellant had greater prospects of succeeding in appeals when the tilted balance wasn't engaged than when it was. One of the reasons appeared as though it might be to do with the way the tilted balance was being applied and the inclusion of development plan harm in the paragraph 11D2 exercise. And what I mean by that was that the adverse impacts of the scheme, including the conflict with the development plan, would significantly and demonstrably outweigh the benefits of the scheme. So this case challenged two appeal decisions, one in Uttlesford and one in Corby, and in both cases the inspector had carried out the so-called tilted balance and included development plan harm in that exercise. So what we said is that paragraph 11D2 is a policy test that concerns whether the adverse impacts of a proposal significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole, not the development plan. And I hope everyone's reading the wording of paragraph 11D2 right now, as I am, in my teeny tiny little framework, because our first argument is that's what paragraph 11D2 says. It says when assessed against the policies in the framework taken as a whole. And our argument was that you should be able to read a policy and understand what it requires on the face of it. Further, we said that the framework is a material consideration and the development plan is the development plan. Considering development plan harm in the tilted balance imports the whole question of compliance with the development plan into the paragraph 11D2 balance. And we submitted that's not right because it conflates the question of statutory priority, the statutory presumption, with the question of whether a policy presumption arises. And you need to keep the two things separate. Development plan, material consideration. It's also the case that if you find yourself in the 11D2 balance, it's because the development plan is out of date or it's not delivering as it should. You don't get to 11D2 if everything is going swimmingly and you've got a bang up to date plan that's doing exactly what it said on the tin. And if you bring harm to the plan into the tilted balance, you're making that problem part of the solution. So we say, well, that's circular and it's double counting. And it can make the tilted balance less effective than it should otherwise be. And anyway, as I said, Mr. Justice Holgate disagreed with us, as he's entitled to do, of course, but we're off to talk about this to the Court of Appeal later on this year.
Fantastic. When's that being heard there?
November.
Great, okay, that's what I thought. That's what I had in my notes.
If my clients are here, they can say in the chat if I've got that wrong, but I think it's November.
Oh, there we are already, 10th to 11th November.
Oh, great, super, thank you.
Fantastic, thank you. So, Killian, we heard there that part of the claimant's case was actually that housing appeal statistics aren't as favourable as they might be for the development industry. Do you have any view as to why that seems to be the pattern at the moment? Oh, you're on mute.
There we go. I think there's a combination of factors. Firstly, that this shift, which I, like Thea and like lots of people, recognise that the pendulum has swung since, for example, 2012 to how it has been the last few years. Possibly that's down to the fact that some authorities now have a more robust 5-year supply. They've got more up-to-date development plans in place. Thus, the circumstances have perhaps been more positive. However, in the aftermath of COVID-19, we might see a return to those post-recession days of 2012, with many authorities surely struggling with their housing land supply. I also note the Prime Minister came out today and his slogan was build, build, build. So we might see that that's reflected in how appeals go forward. Secondly, there's been a sharp increase in legal challenges, which has resulted in the planning court. I've got to say, I have great sympathy for inspectors. Most of them are not lawyers, yet now when they're determining appeals, they are frequently grappling with a number of complicated legal interpretation issues. To my mind, that is not barristers being difficult. I know I would say that, but that is rather owing to the drafting of various policies being unclear, and our discussion on this deliverable point emphasises that. Thus, inspectors face a much greater threat of having their decision quashed, and I think for some inspectors that makes them more inclined to refuse permission on a subjective ground, most commonly landscape, adopting the mentality of when in doubt, kick it out. And thirdly, I think the advent of localism, I've never thought the deference to neighbourhood plans makes much sense. It appears to be pandering because neighbourhood plans receive much less scrutiny going through the process to actually be made and being adopted, yet they on many occasions afforded greater weight than a local plan owing to the operation of paragraph 14 of the framework. And they appear to be a mechanism for well-organised locals to frustrate development across the country. So those are amongst many reasons why I think the pendulum has swung, but I think it does need to swing back if we are to build, build, build.
Right, thank you. And Neil, how about you? What's your experience on the ground? Has the tilted balance lost its effectiveness?
Well, I mean, it's very hard to generalise because every application will be determined on its merits. But it's clear in my mind that the tilted balance isn't operating effectively because we're simply not delivering enough homes nationally by a very long way. And perhaps of greater concern, the number of planning applications and planning permissions significantly declined in 2018-19. So it's therefore clear that the contingency provided by the tilted balance to support the plan-led system is not performing in achieving completions on the ground. Now, the reduction in planning applications, which is the real concern, indicates that applicants are adopting a more precautionary approach, and that will doubtlessly have been affected by economic circumstances, the uncertainty of the last few years, and that's a discussion for another day. But it also appears to be affected by the prevailing or perceived trend of the tilted balance not being sufficiently tilted, as with the stated position of Gladman. Now, if Gladman are right and the tilted balance isn't sufficiently tilted, we become entirely reliant upon the plan-led process to deliver a sufficient supply of housing. And as we all know from long experience, the development plan process just isn't sufficient to do that. Therefore, as an inevitable consequence of an insufficient tilt, we won't boost the housing supply and we won't address the housing crisis as required by government. Even if the tilted balance is sufficiently tilted, but it's perceived not to be, that's likely to result in the same outcome because applicants will be dissuaded from submitting planning applications to deliver the number of houses we actually need. And in my mind, it's very clear that we need government or a written ministerial statement to outline precisely how the tilted balance should, well, not precisely, but to provide further guidance on how it should be applied and the weight to be afforded to various considerations.
Great, thank you, Neil. I think you'll have a lot of sympathy in the audience with what you're saying. We've had just a couple of comments in on the chat. One of them, Killian, I don't know if you want to pick up the point about neighbourhood planning and the fact that because there's a referendum and it's adopted post-referendum, it therefore has legitimacy. What would be, do you have any comment to make there?
Yeah, I'm not suggesting neighbourhood plans should be done away with, but where a local plan is out of date by virtue of a 5-year supply and neighbourhood plans can be out of date where there's more than a 3-year supply, it shows that there is some greater deference to a neighbourhood plan than a local plan. And ultimately, both plans are adopted through a democratic process. The referendum applies for neighbourhood plans and it's subsequently voted on or made by the council. And the local plan, that goes through the democratic process. It is the council's plan. There's a much vaster consultation being conducted in respect to it. So they both go through that democratic process, but in terms of the attention that they're given, they are given an alarmingly light touch by inspectors. The requirements that you have to go through to get a neighbourhood plan through the process are much less extensive than a local plan, and yet they can be they can frustrate more development. And that inconsistency, I never understood where that comes from.
No, it's totally disproportionate. I agree, Killian.
Good. Well, I think we're going to have to bring it to a close there because we are our half an hour is up. We're going to stay with the housing land supply next week. We're going to look at the effect of lockdown and COVID-19 on housing supply. And in the chair, we're going to have Dr. Ashley Bowes. So we do hope that you can join us same time next week, same Zoom details. Thank you so much.
Thanks very much as well.
See you guys.